Hey, good morning. Welcome to another edition of Coffee with CartLawAlabama. I'm Darrell Cartwright, an attorney in Birmingham, Alabama, and wanted to talk to you today about something that we started last week, a discussion last week on what I like to call criminal law chicanery. Let's take a quick look. And here we go. Part one last week, we talked about how a civil statute and with criminal elements, the Racketeer Influenced and Corrupt Organization Act, or RICO, was used to put away or convict rhythm and blues singer R. Kelly. We talked about how he now shares the same things in common with mob bosses, the head of Hell's Angels, etc. Well, today what we're going to talk about is something a little bit different. Lawyers and other reptiles. It's a serious subject, and I don't mean to make light of. This is a book that I actually own, and it's pokes fun at lawyers in a good-natured way, has some neat little jokes there. Why won't shark attack lawyers? Professional courtesy, of course. What do you get when you cross the Godfather with a lawyer? You get an offer you can't understand. I know I don't do a very good impression. Let's switch back. I'm gonna circle back to the animal reference here in a minute. Everyone has heard of the very famous United States Supreme Court case, Miranda versus Arizona. Your Miranda rights. You have the right to remain silent. You have the right to counsel. In the event you cannot afford counsel, an attorney will be appointed for you, that kind of thing. It basically held that any detained criminal suspect was entitled to be notified of their rights, their constitutional rights, in a meaningful way. One of the offshoots from that is that when the criminal suspect requests an attorney, generally questioning must stop. Now, what does that mean exactly? Well, you kind of got a little catch here. Courts have held although an explicit request for an attorney requires the question to stop, if it's ambiguous or equivocal in some way, then the questioner is not required to stop questioning. Oh, indeed. That brings us back to the animal reference, the lawyer dog. Now, you've probably heard people say things like, hey, I'll hit you up later, dog. And they're not calling you a canine. There's no canine reference there. They're just basically saying, I'm going to call you later, or I'm going to text you later, whatever. I don't use that kind of slang, but my kids probably did, and maybe yours as well. Maybe you do as well. Well, that brings us to what I call the curious case of Warren DeMesme from Louisiana. Warren DeMesme was a suspect and was being detained for questioning by police in Louisiana for a very serious crime. And during the questioning, as I understand it, was the second time he had been brought in for questioning for the same crime. He said during questioning, hey, if that's what you believe, then just get me a lawyer, dog. Well, the police continued to question him, and eventually he confessed. Now, I'm not getting into the whole debate about whether or not an innocent person ever confesses. I've seen good arguments on both sides of that equation, etc. But what I do want to focus on is the subject at hand, and that is his request for a lawyer, or as the Louisiana Supreme Court said, his request for a lawyer dog. Now, I don't know what a lawyer dog is. And I would imagine that he might look something like the picture that we have there, dressed in very nattily in a suit and tie. But according to the Louisiana Supreme Court, asking for a lawyer dog was not an unequivocal, unambiguous request for counsel. Go figure. Now, the interesting part to this is I believe they actually got it right, but for the wrong reason. In the questioning, or at least arguably they got it right. During the questioning, the questioner asked Warren DeMesme different questions and, were basically accusing him of committing a crime. And he said, if that's what you believe, then get me a lawyer dog. Well, I think the Louisiana Supreme Court should have focused on the fact that he said, well, if that's what you believe, then get me a lawyer dog. It was equivocal. It was based upon something that the suspect was conditioning, that if that's what you believe, if you had a belief that I committed this crime, then and only then get me a lawyer. At least that argument in my mind holds water a little bit better than a lawyer dog. In any event, I hope you've enjoyed this. I know we don't talk about criminal law very much, and I don't practice in those fun areas, but occasionally I like to dig into it and see what's up, or what's up, dog, as the case may be. You have a great rest of the week, and I'll see you next time.